You're listening to Members of the Jury, the show that takes you straight into the trenches of justice, where the passion, players, and consequences are real. Each episode, we examine current events happening in the system. From the battles in courtrooms to the streets demanding reform, we bring those stories here to you, the members of the jury, because we aren't afraid to take it to the box.
What's up, members of the jury, and happy Freedom Friday. Welcome back to another episode of the podcast. Today's show is the first of its kind. It's going to be a monthly breakdown of the current events in courtrooms and the legal universe that happened throughout June of 2026. Every day, the legal system asks juries to step inside the most terrifying moments of a human being's life. We asked 12 ordinary citizens to dissect a split-second decision that resulted in a death and decide, was it murder or was it self-defense? Last month, 2 monumental verdicts were handed down, and it pushed this question to the absolute forefront of the nation. Involved 2 different states, one in South Carolina and one in Texas. Completely different scenarios. In one case, there was a 65-year-old convenience store owner who shot and killed a 14-year-old teenager after a confrontation or alleged theft out of the store. And then there was another that involved 2 17-year-olds at the time, high school students who were engaged in a conflict that resulted in a stabbing and a death. Now, both of the individuals were charged with murder, and both claimed that they only used the deadly force to protect themselves or a loved one. But while one walked out of the courtroom a free man, the other was given a 35-year prison sentence. Today, I'm going to break down those 2 cases. One was the state of South Carolina v. Rick Chow, and the other was the state of Texas versus Carmelo Anthony. I'll lay out the facts, the legal backgrounds, and the decisions that were rendered. Let's talk about the South Carolina v. Rick Chow case. The date of that incident was May 28th of 2023. Now, the case just went to trial 3 years later in June of 2026. The incident took place at a local convenience store. The parties were the store owner, the defendant, Rick Chow, and a material witness, although not a co-defendant, his son, Andy Chow. The decedent in that case was a 14-year-old boy by the name of Cyrus Belton. Now, on the day of the incident, Cyrus had entered into the convenience store owned by the Chows. The Chows suspected him of shoplifting several bottles of water. A verbal altercation occurred between them all, and eventually Cyrus ran out from the convenience store. Now, at this moment, the store owner, Rick Chow, and his son, Andy, followed Cyrus out of the store. They pursued the 14-year-old more than 130 yards down the street. At the conclusion of that chase, Rick Chow fired his gun, which ultimately struck Cyrus in the back, resulting in his death. Now, the state charged Mr. Chow, and only Mr. Chow, with murder. The core legal issue of that case was whether a property owner could claim self-defense when they choose to initiate a pursuit outside of their business, and whether the threat level justified deadly force. During the trial, the government made arguments as well as the defense. The government looked at the fact that this was a case of pure anger, not self-defense. The government contended that Mr. Chow acted as a vigilante who, over a minor, mistaken suspicion of shoplifting a water bottle. The government emphasized that the multiple independent witnesses saw nothing in Cyrus's hands and that when he was shot directly in the back while fleeing. The government argued that Mr. Chow, quote, believed a human life was not worth more than a water bottle. But the defense fought back. The defense was represented, or the lead defense attorney was a gentleman by the name of Sean Kent, and along with a gentleman named Jack Swirling. They shifted the perspective and highlighted the focus entirely away from the shoplifting conduct and instead depicted a father who was trying to defend his son. They noted that while Cyrus was running, he did possess his own semi-automatic pistol. The defense relied heavily on testimony from Mr. Chow's son, Andy, who claimed that Cyrus turned and pointed the gun at him at one point during the chase. The defense argued that it was in that moment that a firearm was pointed at Andy that justified Rick Chow acting in self-defense of others and shooting Cyrus. Now, this case, like I said, went to trial. And after the conclusions of several days of testimony and evidence, and what I would argue is one of the best closing statements I've seen by a defense attorney, after 8 hours of deliberating, the jury returned a verdict of not guilty of murder for Mr. Chow, and he was acquitted of all offenses. Now, though the government argued the teenager's gun had actually fallen to the ground during the chase and was never used to threaten anyone, the jury ultimately found reasonable doubt. They accepted the defense's framework that the split-second perception of a pointed gun justified the shooting. If you have the chance, that case was live streamed, and so there is video footage of the closing. And if you get a chance, it's about, I think, just around 30 minutes. I would highly encourage anybody to check it out because it was such a phenomenal closing, both in substance and style. Now, the next case that I want to talk about came right after that case, and I think arguably, therefore, had a lot more eyeballs on it because of the national controversy that the acquittal of Rick Chow came. In that case was the state of Texas versus Carmelo Anthony. That trial started on June 9th of 2026. Now, this incident happened a year prior, on April the 2nd of 2025, at a high school football stadium in Frisco, Texas. At the time, the individuals involved were 17-year-old Carmelo Anthony, who was a student of a high school named Centennial. And the decedent in the case was a 17-year-old named Austin Metcalf, who was a student at a rival high school known as Memorial. On the day of the incident, it was known that during the trial, it came out that throughout the day, it began raining heavily at the track meet. The Centennial High School didn't have a team tent, so Carmelo Anthony sought shelter under the Memorial School tent. Austin Metcalf and his twin brother told Carmelo Anthony to leave multiple times. Verbal confrontation turned physical, and Austin shoved Carmelo. Carmelo Anthony responded by drawing a knife and stabbing the unarmed Austin Metcalf one time in the chest, ultimately resulting in Austin's death. The legal issue of this scenario is that Texas is famous for its robust self-defense laws. But the key legal issue here was the proportionality and duty to retreat. Questions that went across the nation was, does getting shoved by an unarmed person give you the legal right to deploy a deadly weapon? Now, this trial was not videoed. There is no film or footage that came out of the courtroom, although at the time of this recording, a lot of the evidence and media have been released to the public for review, although some things have still remained under sealed and no official transcripts have been released. Now, during the trial, the defense was led by a team of gentlemen named Mike Howard, and I can't remember the other gentleman's name. But the defense argued that Carmelo Anthony was in a public space and that he had every right to be there. While Austin Metcalf had a right to ask him to leave the tent, there was, quote, no legal right to put his hands on Carmelo when Carmelo Anthony didn't listen to the request. The defense argued that Carmelo Anthony felt trapped, surrounded by other students, and acted out of a sudden flash of fear and self-defense when he physically assaulted Austin, especially given the proximity of his brother and the hostility of being in a rival tent. The government countered that. They said that in Texas, there's a hard line on being able to use deadly force. He reminded the jury of witness testimony, stating that Austin explicitly said, quote, I'm not trying to fight you, right before he was stabbed. The state argued that Carmelo Anthony actively provoked a physical contact by hurling insults at the students and daring him to get physical. The government told the jury, quote, you can meet deadly force with deadly force in Texas, but you cannot meet force, a shove, with deadly force, a stab. The government asked the pivotal question, why didn't Carmelo Anthony just walk away or find another tent? Ultimately, after only 2 hours of deliberating, the jury rejected the defense's self-defense claim and found Carmelo Anthony guilty of murder and therefore not even considering a manslaughter. They immediately went into a sentencing trial, and at the conclusion, the jury returned a sentence of 35 years, and he would be eligible for parole after 50%, so about 17 and a half. It should be noted that during the sentencing phase, the defense attempted to argue sudden passion, which, if the jury found in favor of, would have reduced his exposure from 99 years down to a 20-year maximum. But ultimately, the jury rejected that. And they only heard a single witness, which was Carmelo Anthony's mother, who really only presented a notion of asking the jury to provide lenience for her son. But they ultimately came back with a sentence of 35 years. So what should we take away from these two cases when we dissect them side by side? I think they show the challenging nature of self-defense claims and that there are no black and white rules and that each case is truly circumstantial and independent on its own. They show that self-defense is never a blanket legal shield. In South Carolina, even though Rick Chow initiated the chase over alleged shoplifting and was wrong, the jury focused squarely on the final sequence, the alleged pointing of a firearm, making the use of deadly force justifiable in their eyes. And only one witness is needed to establish that fact, and that fact came from the son, Andy. Compared to the case of Carmelo Anthony in Texas, despite the state's aggressive protections for personal defense, the jury drew a bright line at escalation. You cannot escalate a fistfight or a physical shove into a deadly stabbing, especially if the court determines you helped provoke the fight or could have simply walked away. 2 young lives cut tragically short. 3 young lives, arguably. 2 families, 3 families, honestly, devastated. And 2 juries forced to define the exact moment where the future turned into a crime, where fear turned into a crime. If you haven't already subscribed to the podcast, please do so. We release episodes every 2 weeks, and we would love for you to join our community. Additionally, I want to highlight a major case that came out of the Supreme Court, and that was Chetrie versus the United States. And what's important in that case is let's step away from the physical streets and look at a structural shift in the criminal justice system and how criminal investigations can ultimately play out and be conducted across the country. On June 29th, the Supreme Court handed down this significant digital privacy ruling. As a defense attorney, as a prosecutor, or just a citizen who carries a smartphone in your pocket, you need to understand this case. It effectively ends the wild, wild west era of a geofence warrant. Now, this case stems from a case back in May of 2019 out of Virginia. A robber walked into a bank, pulled out a gun, threatened the teller, and walked out with nearly $200,000. Investigators had virtually no leads, no license plates, no DNAs, and a suspect wearing a mask. But they noticed something on security footage. The suspect was holding a phone to his ear as he approached the bank. Instead of targeting specific suspects' phones, police did something much broader. They sought a geofence warrant directed at Google. They drew a 150-meter virtual circle around the bank and demanded that Google hand over the location data for every single device that logged into their location history servers within a 1-hour window of the robbery. Google complied, provided anonymous data for 19 accounts. Police tracked the past of those accounts, narrowed them down to 3, demanded the real names from Google, and ultimately arrested an individual, Mr. Chetrie. He was charged, convicted, and sentenced to 12 years for that robbery. But Mr. Chetrie's legal team fought this all the way to the Supreme Court of the land and argued that geofence warrants are unconstitutional, that general dragnet search that violates the Fourth Amendment. The government leaned heavily on the old, quote, third-party doctrine, arguing that because users voluntarily turn their data over to a third party, and in this case Google, that then they had no reasonable expectation of privacy to that data. Well, in a strong opinion, writing 6-3, the Supreme Court, led by Justice Kagan, struck down the government's argument with incredible force. The Supreme Court ruled that obtaining a person's cell phone location data through a geofence warrant constitutes a Fourth Amendment search and is therefore given the protections under the Fourth Amendment. Justice Kagan noted that Google's location history logs data every 2 minutes, accurate to within meters, mapping a hyper-precise, limited chronicle of a person's life. The court completely rejected the idea that opting into an apt feature means you give up your constitutional protections. Kagan wrote, "People do not forfeit their privacy interests just by doing the ordinary things smartphone users do." So, how does this play a role and impact the criminal justice structure in the United States? What does Chetrie v. United States mean moving forward? Well, it's the end of warrantless dragnets. Law enforcement can no longer treat tech companies like a repository for reverse-engineered suspects lists. They cannot search a crowd of innocent people's data just to find one bad apple. It adds a probable cause requirement. Now, to get a geofence warrant, prosecutors must meet incredible strict particular standards. They have to prove probable cause for the entire geographical area that they are sweeping up. If their circle sweeps in an apartment building, a church, or innocent bystanders, the warrant will likely be thrown out as unconstitutionally overbroad. This forces police back to traditional shoe leather detective work, ensuring that our digital footprints aren't automatically used as a state surveillance tool. As we pivot into July of 2026, the wheels of justice continue to spin with massive nationally watched trials hitting the dockets. I'll be sure to follow up at the end of the month to recover any of the biggest case that I've caught. And if you know of any that you want me to follow, please reach out to me on social media at Members of the Jury. You can send me a DM or PM on any platform, or you can send me an email at lhursty@membersofthejurypod.com, and I will love to follow up. As I leave you, I want to quickly look at a quiet but revolutionary wave of criminal justice reform sweeping through the state's legislators this year. For decades, the justice system has operated on a user-funded model, forcing criminal defendants to pay for their own incarceration through administrative fees, mandatory court costs, and even medical copays, all while behind bars. An innovative reform movement gaining massive steam right now is the wholesale abolition of juvenile and adult administrative legal fees, led by comprehensive policy models pushing through state houses. States are recognizing that tracking down, prosecuting, and collecting these fees costs more money than it actually generates. Furthermore, these fees trap low-income individuals in a cycle of debt, leading to driver's license suspensions and technical probation violations simply because they are poor. By shifting away from predatory court fees and establishing, quote, an ability to pay protections before any fines are assessed, states are discovering they can drastically lower recidivism rates and streamline court resources. And so we would like to see that catch more national attention and be implemented. In closing, whether it's 12 jurors in a box deciding if a physical reaction crossed the line is murder, or 9 justices on the Supreme Court ruling that your location data belongs to you and not the state, or lawmakers realizing that poverty shouldn't be penalized, the law is not static. It changes with the culture, with technology, and with the verdicts delivered every single day. That's all we have for this episode of Members of the Jury. Thank you so much for continuing to subscribe and check out the podcast. And we'll see you back in 2 weeks with our next episode. It will be an amazing jury trial breakdown. Take care. Well, members of the jury, that's our show, and I rest my case. Be sure to come back next episode as we take another matter to the box. If you're a fan of the show, go ahead and subscribe. You can also find us on social media at Members of the Jury. If you want to be a guest or have any feedback, be sure to email us at lhursty@membersofthejurypod.com. Information in this podcast is provided as general reference work as a public service. The audience is advised to check for changes to current laws and to consult with a qualified attorney on any legal issue. The use of this material does not create an attorney-client privilege in any fashion with the podcast, the host, or the guest. This information is for educational purposes only, and no one affiliated with the podcast may be held liable for any decision made based on this information.